I have listened with a lot of interest not only to the previous orator but also to all orators. And I believe that not only is it my duty to give my views as regards this particular piece of legislation, but it is also my duty, Mr. Speaker, sir, to rebut the argument put forward by the Honourable Minister a few moments ago. He himself stated that he would rebut Honourable Uteam. Now, let me say that with all due respect to him, I am still waiting for the rebuttal because I tried to be all ears as regards the arguments that he would bring forward, and I was most interested in trying to listen to what the arguments would be as to why Honourable Uteam was wrong. And it is unfortunate that I'm still waiting for those arguments to be put forward, and he finished his intervention before he could even utter a single word in rebuttal. Now, he did give us his views, and that he said that he stood by that particular piece of legislation. I did not expect the Honourable Minister to have the courage to say that he didn't stand by that particular piece of legislation, otherwise he would have had to resign from cabinet. Now, the fact that he is for that particular piece of legislation does not in itself make the legislation good. I will not, Mr. Speaker, sir, get into the debate as to whether it is an opportune time or not for this piece of legislation to be brought forward today. I will not get into the debate because my honourable colleagues have already covered that particular aspect, and I agree with them. But I believe, in my humble view, that there are other important issues that need to be said. There are important documents of research that need to be read. There are experts whom we are all not, in actual fact, who have to be listened to. We have to learn from them. And that includes me. Because in situations of that particular nature, let me start from the beginning. It is in the interest of the country to find natural resources that can benefit the country. There is no denying that. At the end game is for the people of this country to come out the winning, to be victorious economically and socially. That is all that matters. It is not to sing the praises to any particular leader or any particular prime minister. That is not the way I view things. And this is unfortunate that when I listen to members of government, it seems as though that they have this God-given duty to praise that one man, the prime minister, failing which their discourse would be incomplete. I'll leave this to their conscience and to posterity. What I will say today, Mr. Speaker, sir, is not aimed at hurting anyone's emotion, and if it does, I apologize in advance. But that is not my intent. Yes, it is important to help the country with the new pillars of the economy. And if we can find oil, if we can find any other natural resources, why not? However, we should not lose ourselves in this march towards progress, like we like to call it. We should not lose the minimum of what makes us a civilized society, a responsible people, a responsible parliament. We should not lose ourselves in the process. And that is why, in simple language, we should ensure that whatever piece of legislation we bring forward should be an improvement as opposed to the previous one. And when I listen to my, allow me to call him my friend, Honourable Jonga, the Honourable Member, the Honourable Minister refers to the 1970 legislation, which is the Petroleum Act, and he says that it is an improvement. The Honorable Prime Minister says it is an improvement. The Honorable Minister of Environment says it is an improvement. And when you read the explanatory memorandum, those words are important. The 4 words: a more appropriate regulatory regime. Appropriate for whom and how? How is it more appropriate? In what way is it more appropriate? A lot has been said about Trinidad and Tobago. Does the Honourable Minister and does the Honourable Prime Minister, do our honourable friends on the other side of the House realize that Trinidad and Tobago has a piece of legislation that includes within its various sections the concept of transparency and accountability? The law pertaining to Trinidad and Tobago talks about the necessity to publish agreements, the necessity to gazette decisions of the minister. But our law does not make any provision for such publication, for such an element of making public information. On the contrary, the law in Trinidad and Tobago says that one has to be public, not hide information. But in Mauritius, as my good friends on this side have explained before me, even the agreement that is entered into, there is a beautiful statutory gymnastic that is adopted by the other side to ensure that this is never made public. Now, no one on the other side, Mr. Speaker, sir, can come and tell me the contrary. And I challenge them, sir, to come and indicate to me in this bill, tell me which clause permits, allows, encourages the publication of any agreement entered into with any operator, licensee between government, any clause within this bill that says it shall be made public or shall be deposited on the table of the National Assembly. There is no such clause. And I ask, why isn't there such a clause? The Honourable Minister Lejonga says that it is an improved piece of legislation compared to the 1971. In 1970, the legislation provided, as Honourable Uteam said, that it was possible to apply in a prescribed manner by auction or tender. This legislation does not, Mr. Speaker, sir, provide for auction or tender. And I will explain in a few minutes why it is important to provide for auction and tender. Precisely because I read a document here from the Christian Michelsen Institute of Norway, CMI. And the title of this document, published in 2008, that is available for all to read on the internet, is Grand Corruption in the Regulation of Oil. Grand corruption in the regulation of oil. If one wants to know how to encourage corruption in the field of petroleum exploration, one simply has to avoid making the mistakes that I have found in this bill that is proposed before the Assembly. And I underline it, grand corruption. So whatever the experts of the CMI Institute, a well-known institute in Scandinavia and Norway, that is well respected by all international institutions, it is important to read what they say. That it is indeed an industry where a lot of money can be made, but it is important to avoid the dangers in a regulation, in a law that is not drafted in such a manner to avoid those holes whereby one can fall into the temptation of corruption. And I read here at note 1.5, page 10 of that report of 2008, these, I quote, these are coupled with a tendency among politicians and civil servants to view oil resources as a convenient source of rents for amassing personal wealth and securing political patronage. This document goes on to explain at paragraph 2.4, page 17, in the resource curse literature, it is argued that oil resources may alter these democratic mechanisms since control over revenues can be used to bolster political positions through patronage and to build strong political parties. And I'm going to try to connect it to show how this political party in power is precisely doing what the experts in this document says one should avoid. There's a chapter here that deals with the award of licenses. And it says in this, at paragraph 2.7, page 23, the risk of corruption is probably greatest during the process of awarding licenses. Such awards are often conducted on the basis of direct negotiations with firms through auctions, though auctions following professional auction procedures are becoming more common. So what this report says is that direct negotiations with politicians, that is the risk whereby you are opening yourself to the possibility of corruption. Does this legislation provide for direct negotiations? Yes. Does it provide for the creation of a regulatory body for petroleum activities called the Department for Continental Shelf, Maritime Zones, Administration and Exploration? Yes. Who will be part of that particular department? It does not say. How will they be nominated? It does not say. Who will choose them? We do not know. What will be their remuneration? We do not know. What will be their minimum qualifications? God knows. What will be their conditions of appointment? We seriously don't know. Why, therefore, Mr. Speaker, sir, does this government choose secrecy? Why do we hide such basic information? I am trying to understand, but if I am to give my particular opinion, they will say that I am politically biased. But let me read this particular document of the CMI Institute, the experts, and they say, I quote, auction procedures are an important means of selecting the most suitable company for production, though the pre-qualification phase is equally important. Auction procedures, it says, is an important means of avoiding the pitfalls of corruption. This is the CMI Institute. This is not me saying it. It is not the Honorable Uteam saying it. It is not us in the opposition saying it. It is a respectable and respected institution, the CMI Institute. Mauritius has knocked at their door whenever we have required directions on policy. This institution, their doors have been knocked upon by all governments in our country at different times and epochs. But they say that auction is the way to avoid corruption. This government has decided to remove it from the legislation. And they call it now a more appropriate legislation. And I say it again, appropriate for whom? Yes, it is appropriate for all those who want to steal money. Appropriate for those who want to facilitate the process of grand corruption and theft. Then it makes it appropriate. Yes, this is what CMI says. That's not me. Maybe the Honorable Prime Minister should not think about me as an enemy, but read this document, and then maybe you will see that what I say today is not because I am a political adversary of the MSM, it's because... Yes?
Point of order, may I listen to
Please.
I'm sorry, there's a line which the Honourable Member shouldn't cross, Mr. Speaker, sir. This is imputing motive. What the Honourable Member is saying is that those who drafted this legislation came with up with this legislation, came with the idea, with corrupted motive to steal. to loot.
Then-
This is what he's saying.
Then,
This is
please,
It is imputing improper motive.
I've
Yeah.
never said that.
Honorable Mohamed,
No?
it's a good time, it's a proper time for you to continue your speech, but just withdraw those words.
I never said anything of the sort, so I'm not going to withdraw anything. I never said that. Why should I withdraw what I did not say?
So
You want to stop my speech for him to check. That's what you want to do, because it's hurting what I'm saying.
No, then I have to check,
Check.
and we come back and...
What are the words that I said exactly? Can you quote?
There is a point of order, I'm giving my ruling. The Honourable First Member for Portlace Maritime and Portlace East is imputing motives by stating that those who drafted this legislation came up with this idea with corrected motives to steal. A perusal of the Hansard of what Honourable Shakeel Mohamed said reveals the following, I quote, appropriate for whom? Yes, it is appropriate for all those who want to steal money. Appropriate for those who want to facilitate the process of grand corruption and theft. Then it makes it appropriate, yes. In the light of the above mentioned, I rule by the tone and tone of those words uttered, in spite of the fact that Honourable Mohamed was quoting from the CMI report. In so doing, he clearly implied that the bill has been so drafted so as to allow to steal money, thus imputing improper motives to the Honourable Minister who is in charge of the present bill, in contravention of Standing Order 43 of the Standing Order and rules of the National Assembly. I therefore invite Honourable Shakeel Mohamed to withdraw the said words. Thank you very much.
May I go on, sir?
You already absorbed 15 minutes of your time. I'll give you some more time.
Thank you very much. I was told I have 20, so if you give me more, I'll have 10 therefore. Thank you. It is my duty, sir, to draw the attention of the legislator about loopholes in the bill. And when I refer to the CMI report, and the CMI report says that one of the ways of avoiding the pitfalls of corruption would be to introduce the possibility of an auction as a method of avoiding corruption, I believe it is therefore a duty of mine that I have accomplished by drawing that there is a pitfall, there is a lacuna, there is a hole that people could take advantage of, and I'd like to clarify my position on this matter. There is another section of this particular piece of legislation that my other friends have addressed, and I think it is important that I address it. It's only a question of one's own opinion about the way a country should run. Back in the old days, be it in the 20s, the 30s, the 70s and the 80s, it was normal to concentrate power in the hands of one man. It was totally normal to concentrate all power of decision, even if we are in a democracy, not in parliament, but in the hands of one man. Let us not forget our legislation when it comes to citizenship, nationality. It is one man who has the discretion to grant nationality or not to grant it. I am one of those who believes in a rule-based society. Previous prime ministers have also benefited from this legislation, whereby the discretion is there for them and no one else on matters of nationality. I am someone who does not agree that discretion should reside in the hands of one man. I am someone who believes that it is wrong and a wrong democratic principle used by all previous prime ministers. I'm not saying abused, I said used, because the law is the law. But it should be something that should be left in the past. And what I'm saying here is that when you look at the reports of the CMI says that this practice of giving the power to one man is a risk that there might be corruption. Let me underline the fact, Mr. Speaker, sir, is that the issue is not Honorable Praveen Jagannath. I'm not in any way pointing my finger at him. I'm talking about legislation that is being proposed, and I am against the fact that any Prime Minister of any political party holds such power. Even if it was someone of the Labour Party, I stand against any power being given to any Prime Minister of any political party. Is that clear? That is not pinpointed towards one man, but the principle. I am entitled to my opinion. One may not agree with it. One may believe that you have to concentrate all power in the hands of one Prime Minister. I do not. Well, let us respectfully disagree with one another. I believe that we should have a select committee of parliament, as almost suggested by the Honourable Leader of the Opposition. Because we're talking about here property that belongs, potentially property that belongs, if found, to the people of this republic. Should it not therefore have a permanent select committee of the House in order to be able to review and to act as a watchdog with regards to the possibility of avoiding corruption? Because the issue, I say again, I shall not go so low as to limit it to one Prime Minister, and that is Honourable Praveen Kumar Jagannath. That is not what I'm trying to get at. Because tomorrow we may have another one. Another Prime Minister. And then what do we do if we have another Prime Minister who is hell-bent on abusing the power that you're here proposing in this legislation? What are les garde-fous? What are the measures that are included in this legislation that will protect the country from a madman? What do we do, Prime Minister? What do we do, Mr. Speaker, sir? That is why I say, unfortunately in this country, when you suggest something that goes against what the other side proposes, you are treated as though that you are an enemy of that. But I'm not being an enemy. I'm just saying I do not agree with the system of governance that you propose. And I'm not saying that what you're proposing is purposefully done out of malice. I'm not saying that what you're proposing is done with an intention to defraud. I'm only saying that the risk is there. And when you legislate, you don't legislate for you only. You legislate for the governments that will come ahead in future. And you have to ensure that there are ways and means that a mad Prime Minister would not abuse of this power that we're writing in there. You do not legislate only for your understanding of what morality is. You legislate for the possibility of danger looming over our heads. So the power is unlimited. And when you look at the legislation provided for in Trinidad and Tobago, such a blanket provision, a blank check that's given to one man to decide, is not there in the legislation. Yes, Trinidad and Tobago has more experience as opposed to Mauritius in the field of offshore petroleum and onshore. So we have to learn from them. And that is why when I read in this particular document of CMI, and it says here at page 30, and I will gladly communicate this document to the Honourable Prime Minister, who may go through it and will see that what I'm saying here is not out of spite, but out of my love for my country. It's not out of spite. So what I say here, when I read, another way to strengthen accountability is to require status reports from those in positions of responsibility and to ask them to defend their choices. This simple means of improving the quality of decision-making is not necessarily applied. At the highest level of the political system, the ministry responsible for the oil industry should report to Parliament once a year to explain and defend choices relating to regulation of the industry. As the Honourable Prime Minister is proposing this bill, such safeguards are not there. So what I'm only asking the Prime Minister to consider is the following. Is it possible to improve this piece of legislation by giving back to Parliament the power that the people should have, which is to act as a guard dog, to act as a watchdog to ensure that this power is not abused, that you report to Parliament once a year. And if you wish to report more than once a year, feel free. But at least that this concept is there. Previous governments, and I recall at some point in time, not only limited to the Labour Party, but previous governments, have, in matters of corruption, decided to have a permanent committee to oversee the Prevention of Corruption Act and the ICAC. Why? Because it is important to the national integrity. But why is it not an equivalent, a parallel we can draw? That we can also say, okay, wait a minute, this is not property that belongs to any political party, but to the people of Mauritius. Therefore, set up this committee, a permanent select committee that is there, that can question those in power, those people whom we do not know will be in that department. How, who, when, in what way? How will they be nominated? That we can question their choices in the name of our democracy and for the people. That is the only thing I'm suggesting. That we find oil, I hope we do. That we find natural resources, we pray we do. But what I'm asking the Honourable Prime Minister to do, sir, and I'll finish on this, is to do things properly. Do not, what you're doing there, I do not want it to be done in my name, because it can be improved. And let us not do what you're proposing in the name of our children, because they may suffer. Because you could end up by legislating, and then there is no God who provided for, and then on termine avec un fou. And that is the danger which I'm trying to suggest we can avoid if we do not consider ourselves necessarily because we have different views as